This is only for reference. I'm not reading, my lord. 146.3,
G.
152 and 159 clause
152?
152 and 159 clause 4. Under these provisions,
152 or 150?
9(4).
G.
Under these provisions of the Constitution, the Chief Justice is empowered to appoint an arbitrator in certain fiscal matters, in certain disputes, my lord. Now, under the original Constitution, prior to the 22nd Amendment, the Chief Justice was empowered to appoint a caretaker, Chief Election Commissioner, out of the judges of the Supreme Court. Under the original Constitution, prior to the 17th and 18th Amendment, the Chief Justice alone acted as a consultee for appointments in the judicial.
What is the point you're making?
My point is, my lord, that when we say that the Chief Justice is senior among equals, what distinguishes the Chief Justice from the judges? Administration. Otherwise, the Chief Justice would be equal among equals.
Okay, but you are saying that because these specific provisions of the Constitution specifically mention Chief Justice, so by analogy, he has other powers as well. That's what I've understood from your argument.
By analogy, he is the senior among equals.
Okay.
And you see, where there is a power under 191 to frame rules, the rules are for the purposes, administrative purposes. And in addition to the rules, there are constitutional or there are conventions of the court which have invariably been followed since since the 1956 Constitution, and before that the Government of India Act. So those conventions have also acquired the place of rules, or for that matter, the procedure of the court.
Yes, my lord. Article 268(7) is very much clear to that extent, that anything having the force of law has been deemed as law,
Yes,
my lord.
268(7).
268(7), my lord. Now, what this law has done, the law does not say that the Chief Justice, in consultation with the two senior judges, shall constitute a bench. No. Had it been so, it would be least objectionable. What has been done, my lord, that any two of the three may constitute a bench. So the office of the Chief Justice has been converted into that of a senior judge, or the positions of the senior two judges have been converted into quasi-chief justices. This is my submission, my lord. There is no consultation. While concluding the arguments on the previous hearing, your lordship mentioned to the preamble, Article 2, Article 2A, 227, and I'm grateful that your lordship referred to the Grun norm. No consultation is there in this law, my lord. No consultation. And one potential deadlock which I see, not today, say 50 years from now, my lord, the two judges on one side, the Chief Justice on the other side, 50 years from now. The two decide.
Why 50 years from now? Why
My
not
lord,
tomorrow?
Not regarding the incumbent.
चलें आगे बढ़े ना आगे
मैं एक potential
आप इतना लंबा तमलीग बांध रहे हैं
मैं 5 मिनट में खत्म।
चलिए कह दीजिए
If the two judges are
हाँ ठीक है तो it be a minority big deal
and the two decide
so what
that my honorable the Chief Justice, we have established, we have created a roster, and according to that, for the next month you will do the chamber work.
ठीक
You will not sit on a bench.
ठीक है
So the office of the Chief Justice has been paralyzed, my lord.
the Chief Justice can do so himself.
I'm not saying, my lord. I'm
So
not saying.
it implies the Chief Justice can do so, it's okay.
I'm not saying
But
this.
if two senior judges do so, it's wrong.
My lord, there cannot be
या तो
any.
कहें कि कर ही नहीं सकते हैं तो बात खत्म हो
There
गई.
cannot be any Supreme Court without the Chief Justice. This is my point.
We know that because the Constitution
The
says
Constitution says.
Yes.
And that would tantamount to sending the Chief Justice on forced leave. Such like enactment made by a dictator has already been nullified.
तो इसका मतलब ये हुआ कि अगर चीफ जस्टिस के पास पावर हो और वो कहते हैं कि ये दो जजेस जो है ये अगले 1 महीने तक चैम्बर वर्क करेंगे फिर क्या होगा?
अगर कोई डिफिशिएंसी है रूल्स
अगर
में,
में चले तो अगर ये भी हो सकता है
अगर डिफिशिएंसी, आई एम नॉट सेइंग, आई एम नॉट गोइंग टू द विजडम ऑफ दिस लॉ, आई एम रेफरिंग टू द पोटेंशियल डेड एंड वी मे गो इनटू.
ठीक.
लर्नड काउंसिल
पहले आगे
अभी
बढ़े.
तक लर्नड काउंसिल अभी तक आप फ्यूचर का बता रहे हैं. एज द लॉ स्टैंड्स टुडे, हाउ आर यू इनकन्वीनियंस्ड? आपका कौन सा पर्सनल राइट जो है इन्फ्रिंज हुआ है? एंड व्हाट फंडामेंटल राइट आर यू ट्राइंग टू enforce before us?
That question goes to the maintainability of the petition, my lord. And except for 3, all fundamental rights are subject to law, subject to reasonable restriction imposed by law.
आपसे simple ये
उसी पे आ रहा हूँ, my lord.
either say yes or no. Are you inconvenienced by this law?
Yes.
Has any fundamental right of yours, has it been infringed?
Yes, my lord.
Please kindly tell us what fundamental right are you trying to enforce?
Yes, my lord. I'm referring to that.
You don't want,
I have the
you
prime
don't want
right.
access to justice to be...
No.
कुछ और infringement बता रहे हैं मुझे बताइए.
Yes, my lord. All fundamental rights except for the dignity of man, enforced labor and slavery, all have been subjected to law. Now the law means
dignity of
validly
the Chief
passed
Justice?
law, validly passed law coming from a competent legislature, that I may not be subjected to a law for which the respective legislature is not competent. This is all fundamental rights are involved, my lord. And the mother of fundamental rights, Article 4.
ये infringement का बताइए ना, कौन सा fundamental right infringe हुआ?
My lord, if the law is maintained without the necessary legislative competence, it means I'm subjected to a law for which the parliament was not competent. So it is going to affect every fundamental right.
ठीक. और कोई point?
Now, furthermore, under the constitution, all judges are equal, my lord.
जब कह चुके हैं
नहीं आगे बढ़े ना.
मैं आगे बढ़ता हूँ.
अब हमें कोई लेक्चर ना दीजिए जो लॉ स्कूल में देना चाहिए प्लीज.
ठीक है, मैं अपील पे बहुत कुछ कहा जा चुका. मैं सिर्फ एक पोटेंशियल मिसयूज, एक पोटेंशियल. My lord, under the impugned act, the committee of 3 judges may themselves sit in a bench constituted under Article 184(3). Now the judgment comes and there is an appeal stage. Now the same committee will decide as to who should hear the appeal against our judgment.
So what's wrong with that?
My lord, it amounts to appealing unto Caesar against Caesar. There is a potential conflict of interest. If I would have been a judge, I would have an interest that my judgment is preserved.
When you become a judge, we can look into it.
No. So this,
बस.
and my lord, मैं दो points करता हूँ. As per section 77 of the Act, which says that every case having urgency or where there is a prayer for interim relief shall be fixed within 14 days. Hardly there would be a case in which there is no prayer for interim relief. So
There will be what?
in which there is no prayer for interim relief. Almost every case has a
I think
prayer.
you're mixing up the concept of interim relief with urgency.
The word interim relief has also been
ठीक
used.
है, okay. So
May I read
we
one
can apply our brain, which we do occasionally.
Okay.
And we can determine what is
what
urgent and what is not urgent. So what's the big deal about?
What is objectionable? What is objectionable? that the affairs of the apex court have been micromanaged. Even the civil court ordinance, even the CPC doesn't micromanage the affairs of a civil judge. It is in a way contemptuous. It is insulting. Throughout the world, we have phrases like case management, court management. These are the inherent powers. These are always left to the court, let alone the apex court.
Actually, I'll tell you what we did. I've constituted a committee for case management. So I have given my powers already to a case management committee. So you are saying that act of mine is unconstitutional.
No,
Only I can do it myself, or the full court can do it.
no, my lord. It is for this honorable court to do case management. Whoever is delegated that function, it is. But the law cannot micromanage those affairs.
Okay. Shall I next point?
Now,
Your point is that by enacting this law, a power of micromanagement has been conferred on the Parliament, which would open the door for it to micromanage not only these things, but subsequently any other thing that it needs to interfere with.
yes, my
And
lord.
that would affect the separation of powers and the independence of the judiciary.
Yes, my lord. And in legal philosophy, it is called the slippery slope theory.
Sorry?
Slippery slope
Slippery
theory.
slope.
Yes, my lords. Once you are on a slippery
चलिए
slope.
आगे बढ़ें.
Now, concluding my
Learned Counsel, there was a judgment from the Peshawar High Court regarding the
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है. सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट केस की समाअत जारी है. कोशिश करें कि वकला अपने दलाइल आज मुकम्मल कर लें. आज ही केस खत्म करना चाहते हैं. चीफ जस्टिस काजी फायज ईसा ने फुल कोर्ट समाअत के दौरान ये रिमार्क्स दिए हैं. केस की समाअत पाकिस्तान टेलीविजन बराह रास्त नशर कर रहा है.
बाहू दवाखाना रजिस्टर्ड. आपकी सेहत और तंदुरुस्ती हमारा नस्ब ऐन है. अपनी बीमारी से मायूस अफराद के लिए उम्मीद की किरण. अब इसका इलाज महीनों में नहीं, हफ्तों में नहीं, दिनों में. बीमारी चाहे जैसी ही क्यों ना हो, आपको परेशान होने की जरूरत नहीं. अल्हम्दुलिल्लाह बे औलादी का कामयाब इलाज. मर्दाना कमजोरी, मुल्क भर में कमजोरी का इलाज करने वाला वाहिद इदारा. दिमागी कमजोरी, आसाबी कमजोरी, जिस्मानी कमजोरी, जोड़ों का दर्द, शुगर, ब्लड प्रेशर, कमर दर्द, पट्टों का दर्द, दर्द गंठिया, नजर की कमजोरी, बवासीर खूनी और बादी का जड़ से खात्मा. हेपेटाइटिस का कामयाब इलाज. मैदा के तमाम अमराज का शर्तिया इलाज. मोटापा, निस्वानी होसुन में कमी, लिकोरिया, चेहरे पर कील छाइयां, कद में 5 इंच तक का यकीनी इजाफा. औरतों और मर्दों के तमाम पोशीदा और पेचीदा बीमारियों का कामयाब शाफी इलाज. हर तरह की बीमारी का शाफी और कामयाब इलाज किया जाता है. तो मायूस होना छोड़िए, आज ही तशरीफ लाएं. एड्रेस झौमर्रह रोड, बिस्मिल्लाह होटल स्टॉप, मंसूराबाद, फैसलाबाद. राब्ता नंबर 0300 7274 169 0313 725 1800.